Lawyers. What's the most embarrassing thing someone said in court that destroyed their case instantly? I was second chair on a divorce case that started out as routine, at least on paper. Husband and wife, married 9 years, no kids, decent wealth, but nothing outrageous. The only red flag? The husband had fired 2 previous attorneys before retaining ours, claiming incompetence and conflict of interest. That's usually code for they didn't do what I told them. The client, we'll call him Martin, had one mission: to annihilate his wife, Teresa, in court. According to him, she was a pathological liar, a cheater, and a gold digger. He wanted nothing to go to her. No house, no car, not even the dog. He was willing to spend more on legal fees than what she was asking for in the split. That told me everything. But the thing about scorched earth strategies, they almost always backfire. From the start, something felt wrong. Teresa wasn't combative. She wasn't even angry, just exhausted. And eerily consistent in her story. She'd supported him through grad school, took care of his mother when she had cancer, and helped build his boutique consulting firm from a kitchen laptop. But legally, none of it was in her name. No equity, no contracts, no pay stubs. He'd made sure of that. What he didn't count on? The letter. It came out during discovery. A 2-page email dated 6 years prior, where Martin explicitly thanked Teresa for being his partner in everything, and promised her equal ownership of any future success. It wasn't legally binding, but it was damning in terms of optics. We tried to argue it was romantic hyperbole, but the judge wasn't buying it. So Martin pivoted, claimed the letter was fake, said she wrote it herself, using one of his old email accounts and formatting it to look like a message he sent. It was bold, and if true, a felony. He even filed a criminal complaint for forgery, which meant digital forensics got involved. That's when it got interesting. The forensic expert, paid for by him, mind you, analyzed the metadata and concluded, with 99.8% certainty, that the letter had been typed from Martin's own IP address on his own laptop during a period when Teresa was out of the country. Passport stamps confirmed it. Cornered, Martin panicked, claimed maybe someone hacked him to frame him. The judge was not amused. But nothing, prepared us for what happened on the witness stand. It was cross-examination. The opposing counsel, a stone-cold litigator named Marla King, was methodical, quiet, deadly. She walked Martin through the timeline, made him repeat that Teresa never contributed financially, that she never sacrificed anything, that she was just a housewife who did yoga and made smoothies. Then came the moment. Marla, do you recall this document, Mr. Riley? Martin, no, I've never seen it. Marla, you're sure? Martin, yes, that's a forgery. She created that to trap me. Marla, and what makes you so certain? Martin, because I'd never use language like that. I don't talk like that. I never said she was my partner. That's a lie. Marla, so to be clear, this is not your writing? Martin, leaning forward, defiant. No, she wrote it. Marla looked at the judge. Permission to display plaintiff's handwriting sample from his employment documents? Judge, granted. She pulled up an enlarged version of Martin's HR onboarding paperwork from 5 years prior, including a self-written statement almost identical in phrasing, syntax, and structure. The courtroom was dead silent. Marla, is that your writing, Mr. Riley? Martin, yes. Marla, so when you wrote to your employer that your partner and I built this vision from scratch, you were referring to whom? I meant a different partner. Marla, do you recall having any other romantic partners in the last 10 years besides your wife? Martin, that's not relevant. Judge, it is now. Answer the question. He paused. Then, Martin, no. Boom. The damage wasn't just done, it detonated. But what followed was even worse. After Martin admitted, under oath, that the letter he claimed was forged used the exact phrasing he'd written elsewhere, the courtroom cracked. The judge leaned back, clearly irritated but hiding it beneath a neutral stare. Marla, with the precision of a surgeon, didn't gloat. She just waited. Martin tried to backpedal. Martin, look, maybe I did write it. I don't remember everything I wrote 6 years ago. Marla, so you're saying your memory was faulty, but you filed a criminal complaint alleging your wife committed forgery based on that faulty memory? Martin, she manipulated me into thinking I wrote it. Marla, so she manipulated you into writing something kind and generous about her? Martin, yes, she guilt-tripped me. The judge raised an eyebrow. Judge, you're saying this letter, one that aligns with statements you've made to your employer and matches your writing style, was written under guilt-induced coercion? Martin, she was very convincing. Judge, but not convincing enough for you to say thank you to her during this litigation? Martin. Excuse me? Judge. Never mind. The spectators in the gallery tried to hide their snickers. Even the court reporter's fingers seemed to pause for a second. But Martin wasn't done sabotaging himself. In a move none of us anticipated, he asked to clarify something. Martin. Your Honor, I'd like to say this entire situation is being twisted. She made me think we were equal partners. She did. But in reality, she just cooked, cleaned, and did yoga all day. Teresa finally reacted. For the first time during the entire trial, she turned her head. Her expression didn't change, but you could see the restraint, like she was swallowing every scream she ever held back in that marriage. Marla took a slow breath. Marla. Mr. Riley, do you recall the summer of 2018? Martin. Which part? Marla. Specifically, June 3rd through July 25th. Martin. I was traveling for business. Marla. Correct. Who cared for your mother, who at the time was undergoing chemotherapy? Martin. We had a nurse come by. Marla. Would you like to revise that statement? Martin. No. Marla turned to the screen. Exhibit 29 appeared. Hospital discharge notes, home visit records, all signed by Teresa. Daily. For 7 straight weeks. Bathing. Medication tracking. Emergency calls. The works. Marla. Does this refresh your memory? Martin. Maybe. I don't remember every form she signed. Marla. But you remember enough to say she just did yoga all day? Martin. That's not what I meant. Marla. Let's talk finances. You claim she didn't contribute? Martin. Correct. Not a cent. Marla. Would you like to explain this PayPal transaction history? Over $22,000 in freelance marketing invoices, paid directly into your company's business account from her clients? Martin blinked. Martin, that was her hobby. I just let her use the business account for fun. Marla. Marketing clients. Fortune 500 accounts. That's your idea of fun? Martin. It wasn't official. Marla. But you used that revenue to pay for the deposit on your Tesla, didn't you? Martin. Objection. Judge. You can't object? You're the witness. Another chuckle from the gallery. This time, not even subtle. At this point, our lead counsel leaned over to me and whispered, he's handing us his own head. Just let her finish carving. But the absolute climax of the embarrassment came just minutes later. And it was unscripted. Marla. One final question, Mr. Riley. Do you remember writing this note? She held up a sticky note. Bright yellow. Photographed and labeled as Exhibit 31. Martin squinted. Martin. No. What is it? Marla. It reads, move equity out of joint account before filing. She won't notice. Signed with your initials. Dated 1 day before you met with your divorce attorney. Martin. That's not mine. Marla. Interesting, because we found it in your office trash can, recovered by a paralegal who happened to be dropping off materials for you that morning. Would you like to see the building security footage? Martin. You went through my trash? Marla. Your paralegal did. We simply asked questions after. Judge. Mr. Riley, did you attempt to conceal marital assets before initiating proceedings? Martin. Absolutely not. Judge. And this note? You're denying it's yours? Martin. Yes. 100%. Marla. May I approach? She handed over a plastic bag. Inside, a crumpled post-it. Matching handwriting. Matching ink. Same note. But here's where the humiliation turned nuclear. Martin had included that exact sticky note as part of a task in a Slack screenshot he submitted to support his timeline defense 2 weeks earlier. Same date, same note, same initials. He had unknowingly submitted his own attempted fraud as evidence. The judge called a brief recess after the sticky note bombshell. Not to collect his thoughts, he was clearly 2 steps ahead of all of us, but to let the oxygen return to the room. The moment court adjourned for 15 minutes, Martin exploded. Right there in front of the gallery. His own legal team, court security, and most importantly, his now pale-faced lead counsel. Martin, why the hell didn't you tell me they had that note? Counsel, because you submitted it in your exhibit batch, Martin. Martin, you're supposed to check those. Counsel, we did, but you labeled it marketing tasks, Q1. You buried it yourself. He turned red, then purple. Teresa stayed seated, didn't even flinch. She was calmly sipping from her water bottle, staring straight ahead, like this was all just a formality now. After the recess, Martin's credibility wasn't just cracked, it was vaporized. And yet, he insisted on taking the stand again. Said he wanted to set the record straight. That's when we knew. He was about to hang himself in public, and we had front row seats. We didn't even need Marla to ask tough questions anymore, because Martin just started talking. Martin, all I wanted was fairness. I gave her everything. Judge, please stick to direct responses. Martin, fine. But if she wants half, she should explain why she was in contact with my friend Neil. Late at night. Repeatedly. Marla perked up. Judge, are you introducing a new allegation? Martin, I'm just saying, check the call logs. Marla, Mr. Riley, would you like to explain to the court who Neil is? Martin, my best friend. Since college, he helped me get through a rough time after Teresa and I separated. Marla, did you know that Neil is a licensed therapist? Martin blinked. Martin, that's irrelevant. Marla, is it? You're alleging your wife had inappropriate contact with your friend, when in fact she was seeking therapy from someone you personally recommended. Martin, he was supposed to help me. Marla, and instead, your wife booked 2 sessions with him after you left her, to cope with your absence? Martin, he shouldn't have taken her as a client. Judge, do you have any evidence of conflict or malpractice? Martin, he sided with her. Marla, so your issue is your therapist empathized with someone you wronged? Martin, objection. Judge, again, you are not counsel. Overruled. The court had moved beyond snickering. Now, there were subtle gasps. Even the stenographer looked up once or twice, which never happens unless something truly catastrophic is unfolding. But Martin wasn't done. He kept referencing how Teresa only started dressing up after she began suspecting a divorce, that she was suddenly interested in personal growth. Marla let him talk. Every word dug the grave deeper. Then Teresa's counsel called their surprise witness, an older woman, early 60s, well-dressed, composed, introduced as Mrs. Evelyn Hartwell, the former hospice nurse for Martin's late mother. Martin stiffened. He tried to mask it, but his jaw clenched the moment she entered. He muttered something under his breath. Marla, Mrs. Hartwell, how long did you care for Martin Riley's mother? Evelyn, a little over 9 months, off and on. Marla, were you present during the summer of 2018 when Mr. Riley was abroad for work? Evelyn, yes, I handled evening check-ins. Teresa handled daytime care. Marla, can you describe that care? Evelyn, bathing, feeding, emotional support, medication. She did more than most paid caregivers I've worked with. She even turned down job opportunities to stay with her mother-in-law. Marla, were you paid by the Rileys? Evelyn, no. Teresa paid me out of her own pocket. Martin jumped up. Martin, that's a lie. She's been coached. Judge, sit down, Mr. Riley. Martin, she wasn't even there half the time. Judge, one more outburst and I'll hold you in contempt. Evelyn turned calmly toward Martin. Evelyn, sir, I was there. I held your mother's hand when she passed. You weren't. Silence. Devastating silence. Teresa finally teared up. Not from anger, from grief, from hearing someone acknowledge what she went through. Publicly, under oath, Martin's shoulders deflated. The last 5 minutes were just procedural. The witness was thanked and dismissed. Marla turned to Teresa, rested her hand briefly on her shoulder and nodded. But just when you think a man's ego can't make things worse, Martin asked the court for a moment to explain himself to Teresa directly. The judge, in a moment of rare generosity, or perhaps to let the man dig one final hole, allowed it. Martin turned to Teresa and said, "You played this game better than I did. Not, I'm sorry, not I was wrong, not even goodbye. Just that, a courtroom chess match. And he thought he lost a game." After Martin's final speech, no one clapped. No one spoke. The room didn't even shift. It just breathed him out like smoke, a puff of ego that burned too bright and too fast. The judge called for closing arguments to begin the following day. But that evening, we received an update that rewrote the final chapter of the case. It came from our paralegal, a quiet genius named Naveen, who had been combing through the cloud backups Martin submitted as part of his discovery materials. He flagged a folder named Archived Talks Gmail 2016 that Martin had apparently dragged wholesale from his old Google account, intending to use it to prove Teresa was plotting a financial exit years before separation. Instead, it contained something else? Hundreds of emails between Martin and a woman named Colette, stretching from 2015 to 2019. Colette was not a friend, nor a coworker, nor a therapist. She was a woman Martin had met at a marketing conference in Austin. According to their exchanges, they had an on-again, off-again affair for over 4 years. And worse, He had sent her screenshots of his arguments with Teresa, photos of Teresa asleep, voice notes mocking her. In one email, dated just 2 months before filing for divorce, Martin wrote, "She thinks we're going to make it work. Poor thing. But I'm done playing dad to her ambitionless life. You're the one I should have married." That sentence alone made my stomach turn. In another, he wrote, "Once the paperwork is filed, I'll starve her out. No job, no income, no legal standing. I've spent years prepping for this. We didn't have to dig further. We printed 30 pages, filed a motion at 9 a.m., sharp to admit them as supplemental evidence. When court reconvened, Marla made a brief statement. We apologize for the sudden motion, Your Honor, but we've only just received these materials last night from the opposing party's own archive. We believe they go to pattern of intent, abuse of discovery and credibility. Martin's lawyer tried to fight it, but the judge allowed it. You opened the door, he said. So Marla read the emails, out loud. Every word, with full names. Martin buried his face in his hands. His lawyer looked like he was mentally drafting his resignation letter. The bailiff winced halfway through one particularly graphic message, where Martin described, enjoying the slow strangulation of Teresa's financial independence. But the worst one, the one that really did him in, was sent to Colette the morning after their second anniversary dinner. She cried when I gave her that necklace. I wish you could have seen it. Told her it was my grandmother's. Got it off Etsy for $40. I almost broke character when she thanked me. So easy, these women who think love is effort. The judge didn't say anything for a full 30 seconds after Marla finished reading. Then, is there any reason this material was not excluded during your discovery review, Mr. Riley? I didn't know it was there. Judge, you submitted it. Martin, I didn't realize. Judge, you archived your own infidelity, and your contempt, and your intent to manipulate the outcome of this trial, and then handed it to the court yourself. Martin, it was for a different reason. Judge, what reason would that be? Martin, to prove she was lazy. Another pause. Judge, dismissed. Martin, what? Judge, your complaint for full asset retention is dismissed. The court finds your conduct egregious, your testimony unreliable, and your character a direct liability to any equitable outcome. Martin, but, Judge, I strongly recommend you remain silent unless you want sanctions for contempt. He didn't remain silent. Of course he didn't. Because Martin Riley had one more mask to pull off, and it was the one he wore for himself. As we packed our things, Martin stood, red-faced, shaking, and said, You don't get it. She tricked me. Played the victim. Just like all of them. The courtroom froze again. Marla, all of them? Martin, my mother. Teresa, my ex. Every woman I've tried to help ends up stabbing me. Judge, Mr. Riley, Martin, I gave her everything, and she made me look like a monster. Judge, Mr. Riley, sit down. Martin, she should be thanking me. Judge, bailiff. Martin was escorted out, still ranting, the sound of his shouting echoing down the corridor like a broken car alarm. Teresa, she didn't follow him with her eyes, didn't flinch, didn't even blink. She just reached into her purse, pulled out a mint, and offered one to Marla. That courtroom laughed for a full minute. The next morning, the courtroom felt different. Not tense, not electric, just quiet. The kind of quiet that settles over scorched ground. Even Martin's attorney showed up in a fresh suit and a dead expression. The kind lawyers wear when they know they're only there to sign the autopsy report. Martin himself did not appear. He had been escorted out the previous day after his courtroom meltdown. We later learned he was briefly detained in the holding area for disruptive conduct and had voluntarily agreed to waive his presence for the final ruling. His own counsel had advised him to do so. Teresa walked in alone. No makeup. Hair up. Wearing a gray sweater and jeans. You could tell she didn't care about impressions anymore. She wasn't here to perform. She was here to finish. The judge entered and went straight to business. No preamble. Judge, after review of supplemental evidence and in consideration of witness testimony, financial records, and direct admissions from the plaintiff, the court finds Mr. Martin Riley's petition for exclusionary division of assets to be entirely without merit. He didn't look up from his notes. Judge, furthermore, we find evidence of premeditated concealment of marital assets, intentional emotional distress, and abuse of court process. Therefore, the following judgment is entered. And with that, he began listing the outcomes. Teresa was awarded 60% of the shared assets, including the house, vehicle, and remaining savings. She was granted ownership of the dog, whom Martin had allegedly threatened to have rehomed out of spite. Martin was ordered to pay all legal fees, hers and his own, due to litigation misconduct. The email evidence was referred to a local prosecutor to investigate for potential perjury and fraud. And finally, this one got the biggest ripple in the room. The judge ordered that any business Teresa had contributed to without pay or acknowledgement be reviewed for back compensation through a separate civil claim. Teresa didn't smile, but her fingers relaxed around the water bottle she held. The last line of the ruling. Judge, let the record reflect that Mr. Riley's own words and materials were the single most decisive factor in the destruction of his claims. Boom. But what made it even more brutal was what came after the ruling. See, court transcripts are public. And lawyers? We read them. 1 week later, Marla King, the litigator who had shredded Martin on the stand, received an anonymous package. No return address. Inside, a USB drive and a note. I used to work for Martin. I've been waiting for this to be over. Thought you should have this. What was on the drive? Recordings. Over a dozen voice memos Martin had sent to a group of entrepreneurial mentees. A Discord server he ran under the name The Riley Doctrine. His brand apparently was domination over disorder. The recordings were grotesque. Martin boasted about how he staged his separation to create sympathy and how no court would side with a woman who can't prove she's more than a +1. He said things like, if she ever thinks she's entitled to half, I'll remind her who wrote the checks. Marriage is the best business move when you can write the rules. And I wrote mine before she even knew the game started. She thinks love's a negotiation. I'm just better at closing. And the worst? Even if I lose in court, I win in life, because I'll never need to say sorry. Marla didn't even forward the recordings to the court. Not yet. Instead, she passed them to Teresa's new civil attorney. Because this wasn't over. A new case was already forming. This time about unpaid labor, fraud, and financial abuse during their marriage. With witnesses, with timestamps, with digital receipts. The monster had kept trophies and bragged about the hunt. A few weeks later, I ran into Teresa outside the courthouse. She looked lighter, not healed, but beginning. She asked me if she was overreacting by pursuing further action. I told her, "You're not overreacting. You're responding." "That's different," she nodded, then asked me a question I didn't expect. "Do you think he ever really loved me? Even a little?" I didn't answer right away, but she smiled first. "You don't have to lie," she said, and walked away. That night, the court transcripts trended online. Someone posted an excerpt of Martin's line, "She should be thanking me," and it went viral. The internet did what it always does. The memes were savage. The comments, divided. Some people argued Martin was a textbook narcissist. Others blamed Teresa for staying too. Some even questioned if the whole marriage had been real at all. But that's the thing. In court, reality isn't about opinions. It's about evidence. And Martin brought all of his own lies, typed, stamped, and notarized, into the courtroom like he was proud of them. The fallout wasn't fast. It was slow, ruthless, and thorough. Martin Riley went from being a respected local entrepreneur, often quoted in articles about grit and leadership, to an online case study in self-destruction. Legal forums dissected his testimony line by line. Reddit threads linked screenshots of his court submissions, all legally accessible, because he himself made them public. Even LinkedIn wasn't safe. Someone reposted his old motivational posts under the caption, "Imagine writing this while planning to bankrupt your wife." But it wasn't just internet infamy. After the court's ruling and the discovery of the voice recordings, Martin's consulting firm lost its biggest client. Not because they took a moral stance, but because the case had made his name toxic. HR reps Googled him and backed out. A board member quietly resigned. His speaking engagements were canceled. His alumni network severed ties. And the mentees in the Riley Doctrine server? Most were just lost kids in their 20s who thought alpha advice would help them build confidence. When they heard the full recordings, many of them turned over DMS to Teresa's legal team. One message in particular stood out. It was from Martin to a mentee, timestamped during the first month of the trial. "I've got this judge figured out. He hates weak women, you can just tell. All I have to do is make her cry once in court and I'll win." That one sentence, "make her cry once and I'll win," ended up in the summary report for Teresa's civil suit. She didn't cry that day, but when the new trial began 6 months later, she read that message aloud in court. Her civil claim was devastatingly strong, and the court awarded her an additional judgment, back compensation for over 1,600 hours of unpaid business support, damages for emotional manipulation and reputational harm, full ownership of Martin's professional YouTube content and monetized platforms because she had written most of his original scripts, and a formal court declaration that Martin had committed financial coercion under state law, something that, while not criminal, became a legal precedent used in 2 separate cases that year. But here's where it gets even darker. Colette, the woman from the emails, eventually came forward, not to support Martin, not even to apologize. She contacted Teresa's legal team and submitted her own statement under oath that Martin had lied to both of them. He had told her Teresa was violent, mentally unstable, and that she refused to let him leave. Colette had screenshots of chats where Martin pretended to be terrified of his wife. In one, he wrote, "She threw a mug at me last night, shattered it on the wall. I slept in the car. Except on that date, Teresa was at her sister's for the entire weekend, with selfies, timestamps, and a full itinerary." Colette's statement wasn't legally required, but she gave it anyway, and it helped solidify the case that Martin had orchestrated a long-term campaign of reputational destruction, not just against Teresa, but for personal gain. Because every lie he told wasn't about escape. It was about control. And that's the truth he could never hide behind charm. Fast forward 1 year. I was walking to a downtown courthouse for a completely unrelated hearing, a real estate dispute between 2 cousins. Nothing exciting. As I passed the family law wing, I spotted a familiar figure seated on a bench outside, staring at his phone. Martin Riley. He looked smaller, not physically, just drained. His signature slicked hair was gone, replaced by an uneven buzz cut. The navy-tailored suit had been traded for a rumpled hoodie and cheap shoes. He didn't see me, but I saw his screen. He was scrolling Reddit. The thread? What's the most satisfying courtroom downfall you've ever seen? And yes, his name was in the comments. Over 1,000 upvotes. He closed his phone, covered his face with one hand, and I walked on. That same month, I got a handwritten card from Teresa. It wasn't long, just a folded piece of ivory paper with blue ink. I know lawyers rarely hear thank you without strings, but I wanted to say it anyway, not because of what we won, but because I didn't walk out of that courtroom feeling invisible. You didn't make me a victim. You helped remind me I never was one to begin with. I kept it. Still do. I tell this story not because it was the most dramatic thing I've ever seen in court, although it's close, and not because I want to shame anyone who loses a case. People lose. That's part of law. That's part of life. But Martin didn't lose because the system failed him. He lost because he forgot that the system listens. He spoke. Repeatedly. Proudly. Arrogantly. Loudly. And in the end, every lie he told, every manipulation, every mask, every smug sentence he thought would win sympathy, became evidence against him. Not because we dug, but because he gave it to us himself. Afterward, for the comment section. No, Teresa wasn't perfect. She admitted under oath to moments where she withdrew emotion, times where she stayed too long. She even admitted to reading Martin's texts while he slept, trying to confirm what she already suspected. But you want to know the difference? She never denied any of it. She never needed to. Because real strength doesn't come from pretending you were flawless. It comes from standing, even when you were broken, and saying, "This is still who I am, and I'm not ashamed to be seen." That's the kind of witness the court listens to. That's the kind of story people remember. And that is why the truth didn't just destroy Martin's case. It destroyed his whole illusion.